46. It has 46 chapters covering all areas of private law, and there are over 60 authors involved from both common law and civil law jurisdictions. And Harold and Jessica Crow wrote a brilliant original chapter on the EU. And for that reason, you should definitely get a copy of this book when it is published in May 2026. Now, in this presentation in the paper, I distinguish between the internal and external dimension of directors' duties. So the internal dimension of directors' duties is concerned with price value. It is concerned with the company's interests, often associated with firm-specific shareholder value. By contrast, the external dimension is concerned with the company's adverse impacts on the environment, on the climate, on nature, on the economy, on stakeholders. It is concerned with whether or not directors should address negative externalities. Now, as I would elaborate shortly, the external dimension matters for three principal reasons. Three developments worldwide have actually put pressure on the boards of directors to consider the external dimension of directors' duties. Now, I should clarify. The question of external dimension of directors' duties is important because it asks whether directors should address corporate negative externalities, should address the negative impacts that the company causes to the climate, even if it is not tied to firm-specific shareholder value, and even if in the short term it would lead to a reduction of shareholder value. Therein lies the controversy. Of course, if it is a win-win situation, if addressing negative externalities will improve shareholder value, if there is clear and irrefutable evidence that internalizing negative externalities will lead to an increase in share price, of course, boards would be more than happy to do it, and shareholders would overwhelmingly welcome this development. But that is not always the case, as I said. As a result, boards of directors have a tough call to make. Now, so as I mentioned that this development is important for three reasons, right? The first is the universal ownership debate and the 2024 Delaware Court of Chancery decision in McRitchie versus Zuckerberg. The second, which many of you would know, concerns the EU CSDDD and the US CSRD, which I would elaborate shortly. And the final, which I think the most interesting part of this presentation, concerns state-owned enterprises. They play a critical role in both decarbonization and as well as in emissions. Now, before talking about the external dimension, I should briefly mention about the internal dimension. I think, as many of you would know, it is tried law both under English law, under US law, under the laws of many common law and civil law jurisdictions that directors are legally required to act in good faith in the company's best interest, to exercise reasonable care, skill, and diligence, to avoid conflicts of interest, right? And so on and so forth. And they are legally required to take into account climate risks and opportunities insofar as doing so has a material impact on the company's interests, often associated with shareholder value. But what does it mean to take into account climate risks and opportunities? What does it mean in practice? It generally means that directors should ensure that companies have credible transition plans. They put in place proper governance structures that surface and address climate risks. They put in place internal carbon pricing mechanisms to inform capital expenditure, and they should perform up-to-date scenario analysis to stress test strategy. And of course, many of you here would be familiar with the ISSB standards, which have incorporated the TCFD, okay? Which have been actually adopted by many stock exchanges and regulators. Now, the legal implication is clear. a failure by directors to consider climate risks and opportunities insofar as these risks and opportunities have a material impact on the company's interests could render the director liable for breaching the duty to exercise reasonable care, skill, and diligence, and the duty to act in good faith in the best interest of the company. In my view, the law with regard to the internal dimension of directors' duties is reasonably clear. I think there should be little dispute about it. But the controversy lies in the enforcement of the internal dimension of directors' duties. Now, I think many of you here will be familiar with the seminal case of Klein versus Shell, but just let me recap the facts quite briefly. So this is a UK High Court decision, and in this case, Klein, a minority shareholder, brought a derivative action against Shell, alleging that the directors of Shell have breached their duty under the UK Companies Act Section 172 for the failure to promote the success of the company, and as well as breaching the duty to exercise reasonable care, skill, and diligence by failing to implement a credible a strategy to meet their net zero goals, including Scope 3. Now, there have been several writings with regard to this case, and a particularly influential one is by Lord Cunworth, which gave the inaugural seminar, and I wouldn't want to belabor the points that he made, but I want to emphasize 2 points which I don't think have been adequately emphasized in his critique of this decision. So the court gave several reasons for denying Klein permission to bring derivative action. I focus on 2 here. The court said that there's an absence of universally accepted methodology to meet the goals set by Shell. Number one, that's number one. And number 2, directors must balance commercial considerations with climate risk. And therefore, the decisions made by the directors of Shell fell within the range of reasonableness. In my view, both of the court's reasons for denying permission are non sequiturs. The fact that there is no universally accepted methodology doesn't mean that there can never be a breach of directors' duties. Courts often assess reasonableness without unanimity in an expert field of evidence. Likewise, the fact that the board has to balance competing considerations, commercial considerations, and climate risk does not mandate judicial abdication. Whether a director has breached the duty of care requires boards to adopt an objective standard of care and to examine the board's actions or omissions in light of the quality and sufficiency of information, assumptions, and scenarios. That said, it is also well established in common law that courts are generally reluctant to second-guess board decisions. So what can courts do without second-guessing board decisions? I'm the view that courts can still examine whether directors have used up-to-date scenario analysis, whether they have considered irrelevant factors and excluded irrelevant factors, and whether they have put in place proper oversight systems to address climate risks. Okay, let's move on to the key issue of these presentations. As I said, the key issue here is can and should directors internalize negative externalities, where doing so is not linked to and may possibly adversely affect firm-specific shareholder value. Now, we are familiar with double materiality, right? Because it consists of financial materiality, which is concerned with enterprise value, and there is also impact materiality, which is concerned with the company's impacts on the environment, climate, the economy, and other stakeholders. Now, many corporate impacts are not yet fully internalized by the share price or through corporate law, so that a win-win situation is not guaranteed. In other words, there is a trade-off between internalizing negative externalities and firm profitability. the evidence is quite sobering because the Carbon Majors 2024 database shows that 57 companies are linked to 80% of greenhouse gas emissions since 2016. And notoriously, many state-owned enterprises and private firms continue to expand fossil fuel operations despite and subsequent to the Paris Agreement. So the implication is this: if boards should focus exclusively or primarily on financial materiality, there's a risk of companies causing more externalities. So we should think about how we can use corporate law to require boards to internalize negative externalities. Now, if I have more time, I will discuss this in greater detail. With regard to the question in this PowerPoint slide, is pollution value maximizing? The answer given by Shapira and Singalis in this paper is that unfortunately it is. So in other words, there is a trade-off between internalizing negative externalities and firm profitability. So in this case, DuPont, which is a company based in West Virginia and which manufactures Teflon, and Teflon is used in various contexts, and one of which is the non-sticky substance in many of the frying pans that we have. And so while in the process of manufacturing Teflon, DuPont emitted for decades an extremely toxic chemical called C8, and which entered the water supplies of the community, which of course led to many residents being poisoned, fell sick, and there was also plant explosion. Okay. Now, what makes this case quite notorious is because the three mechanisms that have often been used to constrain corporate misconduct all fail, namely regulation, namely the market, which is reputational constraint, and namely litigation. So these three principal mechanisms, litigation, regulation, and the market, which is reputational constraint, helps to discipline and constrain corporate misconduct. But in this case, all three fail. Now, one of the ironies of this case is that DuPont, prior to its corporate misconduct being detected and being prosecuted, had a long-standing reputation of corporate social responsibility. But secretly, despite its outward projected reputation, the board of directors actually took a quite cynical approach. They said that it would have been value maximizing to continue polluting as long as the probability of detection and conviction was less than 19%. And you may think that, okay, surely, the share price would tank and there could be severe reputational constraints, right? So what makes this case problematic? Because there was a huge time lag between pollution and detection. So when the company was polluting, the water supply, was emitting the toxic chemicals for decades, and it took a long time before the regulators discovered the egregious doing. As a result, by the time that it was discovered, many of the directors have actually retired, or they are no longer serving on the board of directors. And just like many carbon majors, DuPont has an extensive and sophisticated machinery within its own company that sought to fight and to limit the credibility and the diffusion of bad news. So I'm sure you can imagine that many of the fossil fuel companies have this sort of sophisticated machinery that seeks to limit diffusion of bad news and to contain them, right? And to project good news, okay? And the really unfortunate thing in this case is that 10 years, 15 years after the discovery of the wrongdoing, the class action lawsuits were dismissed because claimants could not prove causation. Okay. Now, with regard to the first reason as to why the external dimension of directors' duties are important, consider the first reason, universal ownership. So large asset owners, large institutional investors care about portfolio-wide performance because um, uh, a high emitting company within its portfolio could potentially harm the overall returns within its portfolio. And therefore, it would have an incentive to make this particular high emitting company internalize its external negative externalities, because the failure to do so will harm its overall portfolio value. Now, the implication, therefore, is that directors of the investee company should promote the interests of these universal owners, also known as diversified investors. This implies that directors should address negative externalities. Now, this is not just a theoretical concept. I mean, the fact that there is universal ownership, of course, started off in theory, but many of the world's largest asset owners, such as the Norges Investments, such as Singapore's Temasek, identify themselves as a universal owner. Now, the second development, as I mentioned at the outset, concerns CSDDD and CSRD. Note that these two pieces of legislation do not impose duties on directors per se. They impose duties on the company. So the companies must carry out due diligence to address adverse impacts on the environment and on human rights, right? That's what the CSDDD requires the companies to do so. And companies must report on double materiality. That's what the CSRD requires the in-scope companies to do so. Now, these two pieces of legislation changes what I call the environment of expectation. It actually elevates the standard of care that directors of companies are subject to. Now, the third and final development, state-owned enterprises. They are simultaneously major emitters and key decarbonizers. A really interesting feature of SOEs is that they do not have profit maximization as their sole or dominant or primary value. Okay, they are explicitly multidimensional. Of course, they seek to generate profit, but they also seek to generate employment. They seek to provide affordable goods and services. And they also, according to many SOEs, seek to promote social environmental good. These considerations go well beyond maximization of shareholder value. So the question here is whether Anglo-American law allows directors to address these external considerations. So for that, let's take a look at this really important and very well publicized decision of the Delaware Court Chancery case of McRitchie versus Zuckerberg. This case was handed down only last year. So in this case, the plaintiff alleged that Meta's directors and officers, including Mark Zuckerberg, breached their fiduciary duties by seeking only to generate firm-specific shareholder value and by neglecting the diversified investors or the universal owners' interests. Now, what did the court hold? Here, VC Lester held that directors owe duties only to the company and only to the firm-specific shareholders. There is no duty on the part of directors to diversified investors or universal owners as such, and no requirement to reduce negative externalities. Okay. That said, the court laid down two qualifications. First, the court said that directors must consider broader economic harms, namely directors must internalize negative externalities if the corporate decisions consistently or profoundly harm the broader economy, consistently or profoundly harm the broader economy, and in doing so, harm the interests of firm-specific shareholders. And second, directors can consider broader economic harms, and by extension, directors can address negative externalities if shareholders consent to that. So let's take a look at these two qualifications in greater detail. And I should pause at the moment because, in this book chapter, I wrote extensively about this case of McRitchie versus Zuckerberg, and it's actually my first time writing about Delaware law. And I thought perhaps I should just email the judge, Vice Chancellor Travis Lester, to take a look at my analysis of his decision to see whether it's correct. And I do not know Vice Chancellor Travis Lester at all, no connection, no contact. I just dropped him a message on LinkedIn. I wrote this paper. Would you be so kind enough to take a look? And he replied within about an hour and said, yes, I'll be happy to take a look. And the very next day, he came back with comments. So I am just so grateful. Sometimes judges who are just complete strangers, would sometimes you write to them, you never know. They are so busy, they are so important, but you ask them for comments and they just said, sure, So thankfully, there was nothing wrong with my analysis, so it has, but he gave some important, interesting points for me to think about, actually. So really grateful to him, Now, so when must directors address negative externalities, right? As I said, the test is whether the corporate decisions consistently or profoundly harm the economy, right? And whether that led to a drop in share price, whether that led to the interest of the firm's specific shareholders being jeopardized, right? Now, it is actually a really difficult test to apply. If you apply this test to most carbon majors, directors are unlikely to be in breach of their duties. This is because it is extremely difficult for a minority shareholder of a carbon major such as Shell, BP, Chevron, or any particular carbon major to show that directors have caused BP, Shell, or Chevron, or any carbon major to consistently or profoundly harm the climate, or consistently or profoundly harm the environment. And even if that can be shown, the next step is that the minority shareholder has to show that this consistent or profound harm to the climate cause losses to the firm's specific shareholders. Okay, so and there must be a causal link between what the directors have done, which caused the company to cause harm to. So there are actually three causation. First, you must show that directors' decision caused the company to cause consistent or profound harm to the climate. So two, causation. And after that, once you have established that, you have to show that the consistent or profound harm to the climate or to the economy or to nature resulted in harm to the firm's specific shareholders. Three levels of causation effectively, or three kind of attribution you have to make. So in my view, it is one thing actually for a minority shareholder to show that carbon majors as a whole collectively cause consistent or profound harm to the climate, which will translate to macro harms such as persistent GDP losses or systemic market impact. It is another thing to show that directors of this specific carbon major has caused profound or consistent harm to the climate, which in turn has led to a drop in the share price of that company, which as a result harm the shareholders. This is because the financial performance of a company depends on various factors. Now, I should mention that there's actually quite an important paper by the LSE Grantham Institute, which showed that threatened or actual litigation can lead to a drop in share price. But note that this piece of evidence, this piece of literature, does not show that directors' action caused the specific company to cause long-term harm to the climate. This particular paper by the Grantham Institute, wonderful and terrific piece of scholarship, only establishes that there is a correlation between actual or threatened litigation and share price, which is firm value. Now, so it is very difficult to establish that direct, those causation elements that I've mentioned. Namely, it is very difficult to satisfy the first qualification. When must directors address negative externalities? VC Lester also said that directors can, not must, address negative externalities in two major situations. First, directors can address negative externalities if doing so is rationally related to firm-specific shareholder interests. In other words, if it actually benefits the shareholders of that particular company. Okay, this is quite well established. This is actually the enlightened shareholder primacy model, which has been encapsulated in Section 172 of the UK Companies Act. Travis Lester also said that shareholders can amend the corporate constitution to require that the corporate purpose includes protecting climate and nature and economy. And because directors must act in accordance with the corporate constitution, they will be in breach of the duty to act in accordance with the corporate constitution if they do not give effect to this pro-nature, pro-climate clauses. And the corporate constitution can also be amended to require that directors, in their exercise of powers, address negative externalities. And the corporate constitution can also be amended to list out specifically the beneficiaries of directors' duties, and that could be the climate or nature. Now, as you can appreciate, these kinds of amendments are highly problematic, and I will give you some examples later, because some of the UK private companies have actually adopted this, because it depends on the wishes and the incentives of the shareholders. Ultimately, UK corporate law, just like US corporate law, is fundamentally shareholder primacy oriented. Okay, I'll keep this brief because I think many of you know about these two major pieces of legislation. So for the CSDDD, companies must identify, prevent, and end adverse human rights and environmental impacts in their business operations and in the subsidiaries, right? And interestingly, the CSDDD includes a clause that requires companies to adopt best efforts climate transition plans aligned with Paris Agreement. But of course, there are also the ongoing omnibus proposals that seek to dilute some of these important provisions in the CSDDD. But as far as I'm aware, there seems to be no longer the need to implement the climate transition plan, but the need to adopt this plan still remains. Now, for CSRD, it mandates double materiality, right? Reporting means financial and impact materiality. And interestingly, it has extraterritorial effect, and therefore it applies to non-US companies. But of course, there are the omnibus proposals that seek to extend the timeline and seek to restrict the scope. But as far as I'm aware, the omnibus, double materiality has actually been affirmed, has been reaffirmed, notwithstanding the omnibus proposals. Now, the issue here is this: if the CSDDD and the CSRD have extraterritorial effects, how will it affect overseas companies, such as US companies that have operations within the EU? Okay, what implication does the CSDDD have for directors of overseas companies, including US companies. With regard to US companies, it has been argued that directors of US companies could breach their CARE oversight duties, right? If the CS related risk, if the CS triple D related risks are central to the company and directors fail to establish proper oversight systems, or if they persistently ignore red flags. What about the UK? As we all know, the standard of care that directors are required to adhere to with respect to their duty to exercise reasonable care, skill, and diligence is shaped by regulatory requirements and market expectations. It is not static, it is constantly evolving. Therefore, in determining whether directors of UK companies have breached or have discharged the duty to exercise reasonable care, skill, and diligence, courts will take into account what regulatory requirements have been put in place, what the regulations expect directors to do. So, in other words, it will be really difficult for directors to say that we have not breached our duty of care if it can be shown that they have caused the company to breach the CS-triple-D or the CSRD. Now, SOEs, I think, as I mentioned earlier, they have two important features, right? They account for significant emissions, right? And they are among the world's worst emitters, apart from the investor-owned companies, Shell or BP. They account for more than 50% of planned renewable investments. And if you look at the Carbon Majors database 2024, it is quite telling that 13 of the out of the top 20 carbon majors are state-owned enterprises or under state control. And tellingly, 4 out of the 13 on the list are from China. Now, but that said, although many of the SOEs, they are carbon majors, they also lead in renewable investments. Over 50% of planned investments globally come from SOEs. And as I mentioned earlier, SOEs is a unique kind of company because it has multiple purpose. It is not just concerned with profit generation. So these three major developments worldwide show that it is important for directors to consider the external dimension of their duties. Now, the next part of this presentation considers what are the three arguments that can be put in place to support the proposition that directors should internalize negative externalities, should address the negative impacts that they cause to climate, to nature, or to the economy. Now, the first is that directors can incorporate nature clauses in the corporate constitutions. I'll talk about that shortly, and you have a number of UK examples. The second is that directors can cater to shareholder preferences. This is based on an influential theory by Hart and Zingalis. And finally, in my view, and this is what is most important, there can be an alignment of directors' duties in SOEs, namely the duties of directors, the duties of the controlling shareholders of the SOEs, and the duties of the asset owners can be aligned. And subsequently, I'll mention China, which is an extremely important jurisdiction because it is one of the world's largest emitters, but at the same time, it is also one of the world's leaders with regards to renewable energy investments and production. Okay, now, based on my research, at least 3 UK companies have adopted nature into its corporate constitution. You might have seen this. This is published in The Guardian. This report was published 3 years ago and it reported that faith in nature, which is actually, I hope you might have used one of their products before, a beauty company has appointed nature to its board of directors. Sounds sensational, but actually what it means is that they have made sure that a director within the board has been appointed to protect and to advance the interests of nature, which includes climate as well. Now, this is quite interesting because you see private companies in the UK, through private ordering, voluntarily amending their corporate constitution in order to protect the interests of nature, in order to mitigate, climate change. This is not a top-down approach. There is a set of regulation that's been mandated by the government. As a result, the companies need to change their systems and processes. No, this is voluntary act undertaken by private companies. So what have they done? They have actually amended the corporate object to include references to nature, to include references to future generations. And the director's duty clauses now refer to nature, and there has to be a nature guardian within the board. And there are also clauses stating that reasons must be given if the nature guardian's advice is being rejected, and the nature guardian has to be satisfied with the annual reporting issued by the company. Now, why do all these clauses matter? All these clauses matter because they operationalize the external dimension of directors' duties. In other words, impact materiality is being voluntarily written into the corporate constitution. But unfortunately, in my view, there are a lot of problems with these innovative clauses. Now, the first problem is this. What if directors encounter a conflict between protecting nature's interests and shareholder value? Which one should be prioritized? There is no clause in the corporate constitution requiring directors to prioritize certain set of interests. Directors are required to balance, okay? And there's the second problem is concerned with the core member rule. If you are a corporate lawyer, or if you have done company law, you would be aware of this rather idiosyncratic rule, which means that the rights given to shareholders in a company can only be enforced by the shareholders if these rights are given to shareholders in their capacity as a shareholder, qua members, if the rights are given to shareholders, qua shareholders. So what it means is this. These nature clauses are obviously incorporated in the corporate constitution to protect nature, to prevent further climate change. They are not inserted to protect shareholders in their capacity as shareholders. And therefore, it will be extremely difficult for a shareholder of the company to sue the company's directors or sue another shareholder for breaching these clauses in the corporate constitution. And the other issue is this. Yes, wonderful. You have, this fancy nature on the board, right? You have this nature guardian. But unfortunately, the nature guardian, which is actually a director on the board that has been appointed to advance and protect the interests of nature, has no right to bring derivative proceedings. A derivative proceeding under UK law this right is only given to members, namely shareholders, not directors. And problematically, in my view, the nature guardian, the sole representative on the board, could be removed by the shareholders using an ordinary resolution. So it's just one day, if a majority shareholder is unhappy with what this nature guardian is doing, let's sack him, or sack her, okay? And more problematically, these wonderful, lofty nature clauses can be amended by a profit-driven shareholder who's like, I'm just not happy with all these, lofty clauses that is not doing much work for us as shareholders, that is not making the company profitable. Let's get rid of them. Yes, and shareholders can do so through a special resolution. So you may say, well, there could be solutions to that, right? Shareholders can include explicit priority rules. For example, directors must prioritize the interests of nature unless it causes material shareholder detriment. They can the corporate constitution can also be amended to confer standing power to the nature guardian to bring derivative action, possibly by a nominal share. And you could also have clauses that make it more difficult for the nature guardian to be removed by the shareholders. And you could also include entrenchment clauses so as to make it more difficult for the pro-nature clauses in the corporate constitution to be removed. Yes, it is possible, but once again, you need the consent of the shareholders. As a result, the identity, the incentives, the nature of the shareholders matter tremendously. Now let's move on to the US. So, in the US, for the longest time, corporate interest is associated with shareholder value, which is often associated with share price. But a couple of years ago, Hart and Singalis developed this argument that companies' interests need not be equated with shareholder value, which means share price. Companies' interests should be equated with shareholders' preferences. And therefore, if shareholders have pro-social, pro-environmental, pro non-pecuniary preferences, directors should and are legally required to give effect to these preferences. Okay. And interestingly, right, there are mechanisms that have been put in place by several companies in the US to give effect to these pro-ESG preferences of the shareholders. That includes linking executive compensation to ESG metrics, shareholder proposals, and the company and the shareholders could enter into a legally binding agreements under which shareholders and the directors could carry out pro-ESG transactions. And there's also evidence that ESG metrics in executive compensation are now quite common and do correlate with ESG outcomes. And also, there's also evidence that large index ownership can help reduce emissions as a result of behind-the-scenes stewardship. But the problem here is that there is huge countervailing evidence. Many institutional investors in the US remain financially motivated, consistent with climate's financial materiality. There's also a really telling study that shows that the behavior of the PRI signatories are really hypocritical. Many of the largest asset managers in the US who have signed on to PRI often vote against ESG proposals, right? And the survey shows a minimal willingness on the part of these asset managers to sacrifice even a small amount of returns in exchange for more investments in climate mitigation and adaptation. And as all of us know, there's a huge backlash now in the US. There's huge anti-ESG backlash. And a number of asset managers in the US have been sued in the red states for breaching their fiduciary duties because they took into account ESG considerations in their investment decision-making process. And this remains an extremely live issue. So the bottom line is this: catering to shareholders' preferences is not a good idea. It's not a good basis for the external dimension of directors' duties because of the risk of sacrificing firm-specific returns, which are likely to be opposed by the shareholders. Now, here comes the argument, which is my favorite argument, which I think it is one of the major contributions in the book chapter. In my view, there can be an alignment of the duties of the directors of state-owned enterprises, controlling shareholder of the state-owned enterprise, and the asset owners. Recall that directors are required to act in the best interest of the company, but what does it mean for a director of an SOE to act in the best interest of an SOE? Recall that SOEs have multifaceted purpose. They are established not only to generate profit, but also to produce affordable goods and services, to promote social and environmental good, to generate employment, okay? And therefore, the external dimension of directors' duties is embedded, actually, in my view, in the structure, in the makeup of SOEs. Now, what makes SOEs interesting here is that the state is also the controlling shareholder of SOEs. And the state, as a controlling shareholder of SOEs, has public interest mandates. The state, as a controller, can appoint and remove directors, and it sets expectations. Now, in many systems, the state, as the controller, often exercises oversight of the SOEs, which strengthens alignments between directors' actions and the expectations of the controller. Now, the state here is also an asset owner, what is being called an institutional investor. As an asset owner, it manages diversified portfolios for the beneficiaries. And therefore, it seeks to optimize long-term risk-adjusted returns. And it may rationally internalize negatives in one SOE in order to protect its overall portfolio value. But as I will demonstrate shortly, the calculus can also go in the opposite direction. I'll explain this shortly. There's also a time horizon match, right? The state, as the controlling shareholder of the SOE, and the state, as the asset owner, adopts a long-term approach. This means that they can focus on intergenerational equity, health impacts, and systemic climate risks beyond immediate shareholder returns. But that said, to whom they owe fiduciary duties is actually quite different. For the directors of SOEs and the controlling shareholders of SOEs, they owe fiduciary duties to the SOE, but for the asset owner of SOE, they owe fiduciary duties to the ultimate beneficiaries. Now, let me give you a concrete case study, and this is really interesting. Okay, as I mentioned, it is important to study the world's largest emitter, which is China, and it's also important to study one of the world's most advanced renewable energy investor and producer, which is also China, because it leads in the world in terms of solar and wind power. There's a paradox here, as you can tell. Now, let me give you a picture of what SOEs look like in China, okay? As you could tell here, we have the SOE power plant right in the middle. This is the coal-fired power plant, right? The Chinese government is both the controlling shareholder and the asset owner of this coal-fired power plant SOE. And related SOEs such as the state-owned bank, which provides financing to the SOE power plant, as well as with the grid purchaser with whom the SOE does business with, and as well as the co-supplier. So there are SOEs with respect to grid purchaser, with the state bank, and the power plant itself is also governed by the SOE. And the government, right at the top, is a controlling shareholder and an asset owner. Okay. Therefore, it is overly simplistic to say that the directors or the controlling shareholder of a coal-fired power plant SOE should only be concerned about SOE specific shareholder returns. Okay. The SOE is part of a system of other SOEs controlled by the same government, which is a diversified state investor, which is a universal owner. Okay. And therefore, the directors and controlling shareholders of one SOE cannot be just concerned with the SOE, but must be concerned with the other SOEs, of which it forms just one part. Okay, so directors of SOEs must consider external considerations. And I would argue that the external dimension of directors' duties is an intrinsic feature of Chinese SOEs and possibly many SOEs around the world. And I would show later it is an intrinsic feature of US government-owned utilities. That said, in the case of Chinese coal-fired power plant SOEs, although directors of these SOEs took into account broader economic and social and environmental considerations and prioritize them over firm-specific shareholder returns, they also prioritize them above decarbonization. In other words, decarbonization is rendered secondary to the more important overarching goal of economic gains. So let me explain. So despite taking net zero 2060 pledges, China accounted for 95% of new coal construction in 2023. So this is a puzzle. So on the one hand, you have all these lofty ambitions. On the one hand, you have all these planned renewable investments. On the other hand, you have not really phased down your coal-fired power plants. On the contrary, we have ramped up coal-fired power plant productions. And on the one hand, you are also aware that coal-fired power productions will lead to stranded assets. What is happening? Now, the answer is this. Chinese SOEs decisions are guided by broader economic analysis, not the standard conventional firm-level profitability analysis, which conventional UK, US, and many companies based in the common law and possibly civil law jurisdictions would be accustomed to. Directors of Chinese SOEs take into account external consideration, the impacts on the broader economy, and not just firm-specific shareholder returns for that SOE of which is a director. So some analysis show that coal projects can break even economically within 7 years under certain assumptions, whereas cash flows might not turn profitable for 21 years for that particular SOEs. So from a country economic lens, coal can appear beneficial in the short term. From a firm-specific lens, it looks unprofitable. And therefore, from a country economic lens, if coal production can appear profitable in the short term, you can understand why Chinese SOEs, especially coal-fired power plants SOEs, continue to ramp up production, and the Chinese government have not significantly phased out, let alone phase out these coal-fired power plant productions. Nevertheless, there is analysis showing that shadow carbon pricing shows that net economic benefits can turn negative. Therefore, even on the broader economic view, continued coal-fired power plant production and investment can erode overall national economic gain. So what is the governance implication of this case study of Chinese coal-fired power plant SOEs? In my view, for SOE directors acting under multi-purpose mandates, and for the state controlling shareholder and for the state as the asset owner, phasing down coal-fired power plant operations is consistent with their fiduciary duty if, and emphasize, if future externality costs are properly accounted for. In my view, the Chinese government has not properly accounted for the future externality costs of these coal-fired power plants, which partially explains why it still persists in ramping up coal-fired power plant productions, okay? Because perhaps one reason is that it is so profitable that could be used to help to finance its renewable investments. Now, I come to my last slide. You may say, okay, this is about China. It is important and significant, but what lessons does this case study hold for the US or for other major economies and for many economies that are dominated by SOEs, such as those in Brazil, Russia, Africa, India, Indonesia? First, in my view, it has implications for government-owned utilities in the US. There are around slightly more than 2,000 of such government-owned utility companies in the US, and they account for more than 15% of the production capacity. So these US government-owned utilities have mandates that are multidimensional. As I said, generate profit, but provide affordable energy, generate employment. And so the external dimension of directors' duties is embedded within the US government-owned utility companies. And therefore, directors of a US government-owned utility company must consider, or at the very least, are legally permitted to consider external considerations. And the second takeaway is that the universal ownership argument can cut both ways, right? It is actually a double-edged sword. It can support emissions reductions if doing so it can support emissions reductions if doing so will lead to an overall increase or will not lead to an overall reduction in the overall portfolio value of the universal owner. But it can go in the opposite direction, as we have seen with regard to Chinese SOEs. Because they take the view that if a high emission activity increases near-term economic gains, and which means that it will actually result in an increase in overall portfolio value, they would still allow a significant number of these SOEs to continue to generate negative externalities. Now, the final lesson is this. The Chinese coal-fired power plant SOEs show that there is a conflict between short-term economic gains of continuing coal-fired power plant operations and climate risks and negative externalities. The question is whether directors and investors' fiduciary duties can be used to reduce the conflict. Now, I want to end with this point. SOEs will become much more important in light of the recent ICJ opinion. The ICJ requires states to regulate the activities of private actors, of non-state actors as a matter of due diligence. In my view, the most important non-state actor or private actor in this world is actually state-owned. Yes, thank you.
Very rich presentation. We're giving lots and lots of thought. I am fully aware that it's a few minutes past 5, but I still wanted to take at least 5 to 10 minutes of your time, if you allow us, for questions that you might have. If not, I will also have a question in my back pocket as usual. But yeah, who wants to have a go? Nick?
Yeah.
Go ahead. Yeah, go ahead. We'll take a few questions and then.
I was interested, you sort of spoke about universal asset owners and also this quite difficult test in McRitchie about sort of damaging the environment to the extent that it affects shareholders' interests. I was sort of interested in the implications, maybe not quite for universal investors or investors with globally diversified portfolios, but I'm sort of interested. I mean, if a firm, for example, had a lot of shareholders who invested significantly in parts of the world which are highly exposed to climate risk, do you think there would be maybe a greater ability to demonstrate that that test is passed because the environmental damage is maybe a bit closer to the interests of those shareholders?
This thing, yeah, that might be possible. You have a question.
Yeah, so I think, okay, I see several questions. I think Emilie was first, and then I will go to you, and then to Shasha.
I have a question on the CES Triple D. You've mentioned that the omnibus proposal is basically altering the role of the transition plan. So do you think
That's my understanding.
Yeah. So do you think there's any role for the transition plans if they're not enforceable?
Yeah.
Or
So
do you think under like corporate law, there's a way of maybe enforcing them or like?
am I right, Harold? It's still there.
It's still there, but indeed we'll be adopting, not implementing.
Implementing.
Yeah,
So
that's
does it mean that they're just paying lip service? You can adopt, you can say that we have a plan, but we don't need to operationalize it. Does that what CS Triple D mean?
That's where it's going, yes.
So basically it's just a paper tiger. It looks good, but we don't have to do anything. And so your question is what implications would this have, is it?
Yeah.
Not sure. What can shareholders do? Or what can potential investors? The next step it would be for, I suppose, for shareholders to put pressure on the companies, on the directors to operationalize it, right? Otherwise, there's not much that could be done. This is number one. And number two, it is also possible for a court to use that, I wonder, to say that you have put in place a climate transition plan that's supposedly aligned with Paris Agreement. Yes, we know that you are not legally required to operationalize it under the CS Triple D, but the actions that you have taken are just so inconsistent with the climate transition plan, and therefore you might have breached your duty of care, skill, and diligence. I'm not sure. I wonder whether that could work. Yeah, interesting. Yeah.
Yes, thank you very much for your presentation. It was very interesting. I have a question regarding your conclusion. So you mentioned there is this ambiguity, universal ownership may favor emission reduction or the contrary. It's all a question of balancing gains and costs, right? Now my question is, how do you make this kind of calculation? Because right now the social cost of carbon, like the unit to calculate the negative economic consequences of adding 1 ton of carbon in the atmosphere, I think I read this meta-analysis where it ranges from -$50 a ton to $4,000 a ton, which is a very large range. And I think there is still no consensus at all regarding this metric. So is there any hope of closing this gap in the future of making this kind of calculation? Or is it just something completely impossible to accomplish?
I think you've correctly pointed out a problem. There is no scientific consensus, right? And there's no economic consensus on what a credible shadow carbon pricing will entail. So I think my sentiment, is quite similar to yours. It would be extremely difficult.
Shasha.
Thank you, Professor. Thank you for your insightful presentation. I have a question about Chinese SOEs. In China, SOEs work more like administrative bodies rather than private companies, right?
Right.
Yeah, and it sounds like Chinese SOEs directors consider climate issues mostly because of the government policy.
Yes.
Maybe not because of company law, I think. So do you think such things truly advance climate governance by company law, or just an administrative extension of state power?
I think both, right? In my view, both. We shouldn't let government have an exclusive say in how the company should operate? Because you are saying that Chinese SOEs behavior is often influenced or maybe to some extent mandated by government policies and less so or not so much by corporate laws. But in my view, I think both areas, corporate law and government policies, have a very important part in making sure that companies decarbonize.
Caroline, if I may, I'll throw one question in as well. You mentioned shareholders' financial interest in the McRitchie case. How broad can that be interpreted? We had a quick discussion beforehand about, let's say, attributing certain impact to company decisions, right? Like we know that's very difficult. But at the same time, we also know that in the future, if you continue to build new coal-fired power plants, if companies continue to invest in that might lead to stranded assets over the longer run. But of course, these financial interests are not now, right? Like it's, you might not notice that in the share price now. So is there any way in which these longer-term financial impacts on a company might already be used in arguments by shareholders now?
So interesting. So what you're saying is that let's say if a minority shareholder brings a lawsuit, the minority shareholder will be alleging that in the future, I will be suffering these financial losses because of
the decisions that you're taking.
The decisions that you make now, as opposed to I have already suffered a serious drop in the value of my shares because of what you have done. I've not encountered a situation like that in which a shareholder brings so-called a hypothetical or prospective loss as opposed to actual losses in corporate law. Yeah. Because most of the cases, or at least all the cases that are
contract law
under corporate law.
Corporate law definitely not.
Right, because you have to prove actual losses.
Contract law.
Prove hypothetical losses that even if 10 years later, the evidence shows that this would be the amount of stranded assets.
Because you might have gotten rid of your shares anyway.
Yeah, you might have got rid of it, exactly, yeah.
In contract law, then there's expectation loss, but that's totally different.
That's
totally
different. Yeah. So, but that's a really interesting point, whereby can they make an argument of prospective losses or hypothetical losses? So far, all the cases with regard to derivative action, as far as I'm aware, are actual losses, of one kind or another, yeah.
Last question, Carolyn.
So I'm a political economist, so I have like a very more broad question. I was just kind of curious from planetary health perspective, what do you think is the most transformative pathways that a corporate law regime could move in? Because right now it's looking kind of grim, right? So I'm just kind of curious from a more what do you see as the potential corporate law to, what do you see interesting movements? It's a really broad question. I know. I hate when people ask me these questions, but I'm curious about your response. But the EU used to be a bit more of a shining star kind of, and now it's going downhill. So
what is going downhill?
EU, the omnibus and the CSEE and everything's kind of being rolled back to whatever realpolitik, economic policy, capitalist thinking. So I was just kind of curious. Do you see any bright?
I do see something that could be potentially positive, and that is an alignment of the duties of directors and controlling shareholders and asset owners in SOEs that take the lead in decarbonization.
Okay. And that is mainly then, that's kind of regional specific as well, right? Because
that would be jurisdiction specific.
Yeah. Okay. Thank you.
All right. I'm going to stop us there because we're now 15 minutes over time. So as usual, as I said, there will be some drinks and nibbles outside. Hopefully have a chance to catch up in person with Ernest, who will be around for a bit longer. So thanks everyone for coming. Hopefully see you next week when we're talking about contract law and climate change with Matt Gingell from Oxygen House Group. But in any case, thanks and have a nice weekend.